right, John? Sometimes you can get those people to get the prosecution to come down off the death penalty. So I think that's awfully important. The only one thing I want to say too, just about Batson and just apply to death penalty cases. But the problem is this takes place at every kind of criminal case, race discrimination. So I think, I mean, the problem with diversity, particularly among the judges and prosecutors, is we have so few black lawyers. Because how many black lawyers does this law school have? I was always fighting about it, I know. But it's nowhere near the number of African Americans that are in the population here in Texas. It's nowhere near the population in Georgia. It's going to be generations before we catch up to where there are enough people. And so there really have to be some hard efforts made to decide this has got to be a priority to make the judiciary and to make the prosecution look more like the people who are being adjudicated and prosecuted.
As abolitionists and racial justice advocates, do any of you have any concerns or fears about what abolition will mean in terms of the intensity of the light that's focused on criminal justice?
Well, the light is pretty intense right now because police officers keep shooting black men, and say two things have changed. The whole picture of the criminal justice system, DNA and the cell phone. And we now know, when they say shot the guy in the back, we got a video of him shooting him in the back. They would have never done that before. They would have said, oh, he turned on him and all that. All these things we're learning now, I think people have, and plus the impact of mass incarceration and the fact that it's destroying people and families and communities, and that we have to do something about it. Even the governor of Georgia is trying to get people out of prison. That's a remarkable thing.
What about the judiciary? I mean, you have a case before the Supreme Court that's not before the Supreme Court, unless it's a death case, right?
No. It's a Batson case. It's before the court because there was race discrimination in the jury selection. Even if he had been charged with murder and not been a death penalty case, that may have been a reason they took it.
No, that's what I'm saying. No, I understand that. I'm just saying, is that issue something that the courts are going to spend much time focusing on if it's not a capital case?
Well, Percat in some of these cases, Hernandez. I mean, there have been a number of other cases. I would hope that the court could get away from the death penalty, which is corrupting the court. Not that it's already so corrupt, couldn't be corrupt anymore, I guess, but is totally corrupting the court in all these decisions because they want to uphold the death penalty and want to get people executed. I mean, you look at their 8th Amendment analysis of whether there's a risk of race coming into play. And in McCluskey, they developed this thing out, and only lawyers could come up with this. They say, you know, there's certain procedures the state has to have to minimize the risk. And as long as you minimize the risk, it doesn't work. It doesn't matter whether they work or not. Who operates any kind of business like that where we're going to have this idea and we're going to try it, but if it doesn't work, we don't give a rat's ass? I mean, really? What they have to say is, here are the procedures, and in every case, we're going to scrutinize the procedures, and we're going to see where there was a breakdown. And I think if it wasn't for the death penalty and this finality, I mean, at one time the courts were interested to some extent in justice and in people not being on death row or in prison unlawfully. And now the priority is finality, federalism, and executing people. And I think we'd get all that out of there. I mean, the death penalty has, as somebody said this morning, it's ruined habeas corpus. Habeas corpus used to be a great thing. And it used to be something to be proud of. And Reuben Carter got out. I saw him take it out of his pocket and turn the last page and said, the petition of Reuben Carter for a writ of habeas corpus is hereby granted. H. Lee Saracen, United States District Judge. This was 20 years of serving, of an innocent man serving time. 20 years, a federal district court, he went under the death penalty. A federal district court could let him go. Today it'd be 19 years too late, statute of limitations. But we ought to get back to having the writ of habeas corpus to do what it did, and we ought to be not just trying to figure out ways to trip people up with all these procedural defaults so we can execute.
Well, it might be that in other areas, getting rid of the death penalty will decrease the amount of oversight of the criminal justice system. But with respect to race, there's so little anyway that I don't see that there's really much to be lost. I really think that if you think about why have they taken the Batson cases they have, the reason they've taken them is because they're embarrassments. If you look at Snyder, it's an embarrassment to have someone making an argument that this is the O.J. Simpson case. It's embarrassing. And if you look at Foster, it's like he wrote black by those names. You know, it's like the New York Times is going to print that the Supreme Court doesn't care. And so that's what they care about, is whether the New York Times is going to print it. And I think that doesn't depend on it being a capital case. And I think your cell phone point is similar to that, which is that it's an embarrassment when we have a video. It's embarrassment in San Francisco that the police department now, they've got those text messages that people sent that were racist and sexist and homophobic. And so because it's embarrassment, we're going to do something about it. So I don't think it really is, it has anything to do with capital punishment. I think we respond to race when it's overt and in our face and embarrassing, and otherwise we don't. So I'm hoping for more attention, but I think that that happens not because of capital punishment, but because of sort of the ugliness of particular
But there are the institutional structures involved in people in litigating capital cases that brings energy and people to these cases and to this litigation that might not be around if there's no death penalty.
Well, and I agree with that. That's why I said with respect to other criminal justice issues, that may well be true. Yeah. And there's actually even this move to eliminate non-capital habeas, which has been, so that would be a terrible thing. But that would be terrible whether we have capital punishment or not. But it just seems to me that with respect to race in particular, it isn't really capital punishment that drives attention. Yeah, and the other thing is there might be some of us, I think, will, if capital punishment is abolished in our lifetimes.
Just keep it to yourself, Sheri.
Some of us might think about other kinds of life without parole, other things that.
I think this is one area where I feel a lot more optimistic. I mean, I think, you know, there are some names that resonate nationally. If you talk about Eric Garner, if you talk about, you know, my memory is so bad I'm going to lose the names, but you know, you're talking about Ferguson, Michael Brown. I mean, there are these names that resonate with people across the country. And in the last election, Anita Alvarez lost in Illinois. There's no death penalty in Illinois anymore. You know, that was irrelevant to that. And you know, if you look at the loss in Cuyahoga County, Ohio, the DA lost there. Yeah, that had nothing to do with the death penalty. Right. It had to do with outrage about the criminal justice system. And I think one of the remarkable things about, you know, sort of the shift that I think Breyer kind of subtly enabled or helped along with the focus on the counties and the notion that 85% of us live in counties that are death penalty free. However, there are lots of ways of slicing it. But the fact is, it shifted focus to the county level criminal justice system. And once you do that, you know, whether it's traffic stops or marijuana arrests or, you know, how many folks are without bond. If you go to Charleston County, South Carolina, and if you talk to black folks on the ground there, what they are outraged about is the cop who shot Walter Scott got a bond because he was locked up for 6 months, and the solicitor fast-forwarded Dylan Ruth's trial. And so because she has to prepare for Dylan Ruth's trial, she's not going to be able to reach Schlager's trial. Well, we can't keep him locked up for a year. So he gets a bond. Dylan Ruth, his public defenders have had their caseloads lifted, which means black folks are being warehoused in Charleston and Berkeley County for another year because their lawyers can't file motions and prepare the case for trial. So if you look at the black people in Charleston and Berkeley County in South Carolina, they're outraged, yeah, by this white kid who killed these saints, but they're also outraged by a system that's completely unresponsive to the justice needs of their community. And you know, I take real power in Caddo parishes turning out the district attorney there. You look at California and what's bubbling up with Orange County. You look at the potential changes in Harris. Harris, am I right? There was 0 sentences last year from Harris County? I mean, yeah, I think the potential for creating greater justice at the county level in capital and non-capital cases are really at the highest it's been, you know, since I've been around as a criminal justice professional. And I think the community is now looking at excessive punishments and these other issues. And I think removing the death penalty really is just taking, you know, the cap off. And I think people will be much freer to entertain more progressive criminal justice policies.
We have about 15 more minutes, so I certainly would welcome questions for our panelists. Yeah, in the back.
Talked about in terms of not being afraid to embrace the race issue. I think in many places, Texas, Alabama, where the history is there. I think Brian is doing a whole thing where he's documenting places where lynchings have taken place. It is, I mean, it is right there. Every courthouse that I go to, especially rural courthouses that I go to in Georgia, there's a Confederate soldier right out there. One of the cases in Burke County that Steve came and helped us with, they had a separate World War II memorial for the black folks, which was smaller and you couldn't see, who had died in World War II, and then they had a big one for the white folks. That same courthouse, they used to hang and lynch black folks from it. In a case in Walton County, we embraced it. We started litigating the jury issue, and in it, I kept talking about how Walton County, Georgia, was the last mass lynching in America in 1948. They hung a black woman over the bridge and cut her fetus out, as well as they killed 2 other folks. And I think constantly threatening to bring that up and bringing it up in our challenges, we were able to get the prosecutor to take death off the table. But it's nasty, it is horrible, but it's there. It is there, it's a fact, it's history. And I think sometimes as lawyers, we kind of divorce ourselves from the real history because, you know, we figured out we really know how to do it. But I've just found that in many times if you think about how to embrace that and use it, it can be a powerful tool.
Is that Liz in the back?
I spoke about this yesterday kind of briefly on the panel, which is the issue of challenging death qualification. And I think it's, you know, I really believe, maybe naively, that the time is right to bring some of these challenges. As I said, you know, yesterday, the data is there, and particularly when because, as we know, African Americans are disproportionately excluded through the process of death qualification, that there are opportunities now to challenge death qualification based both on the new data about what death qualification does in terms of both conviction proneness and death penalty proneness. And it is all about race. And it is all about who is ultimately excluded through the combination of death qualification and peremptory strikes. And I don't know if you all have any particular thoughts about it. And I think it goes to what a number of people have said, which is that it isn't necessarily going to be ultimately successful. It has to be done in the trial court. It has to be done with the right kind of evidentiary support. But it creates an opportunity to change the dynamic of a trial, to change the procedures in a trial, even if it is not ultimately successful.
I would just say for the law students here who don't know what death qualification is, if you're summoned to sit on a capital jury, they'll ask you, what's your opinion on the death penalty? And if you're conscientiously opposed to it and can't set that aside, then you're excluded. And it takes out a lot of people. Last jury I had 15 people excluded on death qualification, 11 were African American. So you've taken a group that's already in a minority, you've reduced them into an even smaller minority, and then the prosecution strikes the ones that are left, And that's how you end up with an all-white jury in a community that's 40% African American. So.
I know Craig Haney is working on a survey, I think out of Florida, with the University of Florida, that will be surveying just this point. And I think he's pretty optimistic about what that's going to show. And I can't imagine, but that wouldn't be helpful to the litigators in Florida. They'll have plenty of opportunities to use it. And that may model what we need to do elsewhere.
Oh, I'm sorry.
I think as Jordan's earlier question indicates, looking at LDF is instructive in this context. Two of the limits on what we did that were critical, one was we could never get the court to name race. Starting with Maxwell, the first case, big case, which was all about race, all the way on through Coker, which incredibly didn't mention race, and then ultimately McCleskey really brushing it aside. And so everything you're talking about as lawyers is to get the court to start naming it, it seems to me absolutely critical. And the second piece is something that, as lawyers, I understand 90% of what you talked about was not about this until perhaps Henderson brought it up, but I think absolutely essential is cutting into social movements. That's where it's going to happen. That's how the two are going to be brought together. And abolition is a talking point in that context. So those were the things we did not accomplish, and I think led to the ultimate cap on Furman's legs, if that's not a terribly mixed metaphor. But I think I'd love to hear you talk a little bit more about how the social movements of the day might play into this.
Just in quick response to that question, I believe that the Movement for Black Lives is going to issue policy statements early in the summer, and they will include a position against the death penalty, finally.
I mean, I think it's scary, and it's also a healthy opportunity. I mean, you know, you got a presidential candidate talking about making America great again, and you know, there's a dog whistle to that. There's all this efforts to reclaim the greatness of America, and all that means is, you know, sort of getting the guy in the White House out and reclaiming things. At the same time, you do have a fairly bipartisan, sort of fairly wide range of the community looking at criminal justice issues in a way that's certainly more honest than any, you know, my experience only starts in 81. So I sort of grew up with the war on poverty, the war on drugs, mass incarceration, all of that. That's what I grew up with. And so just to have the conversation, grew up as a professional to have the conversations that we've had for the last 2 years is incredibly uplifting to me. To have had for 5 years or however long the new Jim Crow is, to have that in the debate has been incredibly uplifting to me. So I do think we're sort of seeing two forces about ready to collide, but it seems like we've got the stronger hand. I mean, we are linked both with younger folks who are concerned about equality on different levels, and the conflict with an excessive punishment scheme that seems directed towards folks of color. So I think we've got the stronger hand culturally, with demographics, and that what we saw in North Carolina last week with the rapid special session and the bill signed within 12 hours by the governor. I mean, I think that's sort of like the last gasp of these folks who are trying to hold on to a fairly oppressive reign of terror that they've got because they control the levers of power in state government. And you got similar movements in other states. But my sense is that's not going to survive. I think November will give us some sense of how delusional I am. But I think there's at least now reason to be hopeful about that.
I wanted to make a quick comment because we were talking about how prevalent race is and how we don't talk about it in polite society. And we know that this whole issue of race and racism and the way it affects the criminal justice system is really sort of a cancer that we have not been able to eradicate. In my 15 years as a trial judge in the federal court, I can tell you that I probably didn't get more than 4 Batson challenges, I think 2 of which I made and won. But we don't get that. And in the federal system, most of the judges will do their own voir dire. And most judges certainly are not going to interject that. And so we go through this process of pretending not to see what we see and not to know what we know. And if no one raises that issue, the record is going to be devoid of that. And so when the record comes up to the appellate courts, those who understand what's going on have nothing really to anchor the discussion. And I just raise this to say, you can be polite and respectful as you should, but you've got to make the records and you've got to raise it. And even if the judge does all of the voir dire, you have got to move the judge to really get into that issue and not just that little perfunctory line that means nothing, can you decide the issues fairly and freely with respect to all people absent race. You got to go deeper. And there might be some pushback, but you just got to keep pushing. And I just wanted to make that comment.
Well, and that was my point a minute ago about people not taking advantage of the tools that are there. But I think one thing that's happened with regard to Batson is a lot of people feel like it's hopeless. So they're not raising it. And then, of course, a lot of people aren't raising it because they don't want to get at odds with the prosecutor that they have to deal with day in and day out. And that's got to change.
If I could go back to the question about social movements for a minute, I think one thing that we haven't talked about at all today is Latinos and the death penalty. And I think, we've seen in national politics a huge shift this election where we see the rise of the influence of Latino voters. And if we look at the whole history of litigation of race discrimination and the death penalty, it's been a black-white question, but really, if you start looking at the cases, there's a lot of discrimination against Latinos too, and some of it is actually today more blatant than is discrimination against African Americans. So I think there's a real potential there. I mean, obviously that ought to be corrected, but there's also a potential to involve Latinos in the abolitionist movement, because there's a lot of discrimination there too. And I think there's the reluctance that hasn't been true with LDF. LDF really embraced death penalty litigation. That's not been as true in the Latino advocacy community, but I think it's something that we need to push because it is their community members, and I think for them too, if you can't eradicate discrimination there, it's not as though you're going to find that you've eradicated it in the rest of the society.
We'll take one more question.
So I'm a current LDF lawyer, and so I can't speak to what LDF did decades ago, but I can say now, though, that although abolition is definitely still a priority for our organization, we're obviously concerned about racial justice overall and the overall criminal justice system. And we've had a lot of conversations internally about this kind of moment in history where there's spotlight on the racial bias in the criminal justice system, and the fact that not only is it giving public attention, but that there's really been a groundswell of a movement that's grassroots and also black-led. So it's a movement that's led by the black community and also involving an incredible amount of young people. And so one thing that we've talked a lot about, and I think that as a community, the abolitionist community, we talk about is how to capitalize on that momentum and that movement into the abolitionist movement as well, which is not necessarily characteristic of that being black-led, for example, and highlighting the problems with racial justice within that, because there's obviously parallels when we talk about the racial the racial biases throughout the criminal justice system, whether it's discretion with police officers, prosecutors, within the judicial system, there's clear connections between what the Black Lives Matter movement is doing and all the things that we've been arguing in terms of abolition. And so I think that's a challenge that we have as a community, to make that connection and to utilize all of this energy and potential with the young people that's been so active in recent days. And I think that this is a moment in history where we need to take advantage of that.
And one thing that has to be factored into that is when you look at Liebman's study and so forth, where is the death penalty being imposed? It's only a handful of jurisdictions, but it's places where nobody wants to live. And people have to go to Dothan, Alabama, and Jacksonville, Florida, and several counties here in Texas, and because that's the communities that are, those are the only communities that are sentencing anybody to death anymore. And that's everything, what Tip O'Neill said, all politics are local, and once you can convince that local DA not to seek the death penalty anymore, that's the end of the death penalty in that locality.
Please join me in thanking these panelists.